Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Heather Bowen Pascual brings us a standard vendor agreement. So let's tear it down.
Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. Happy to be joined today with my friend Heather Bowen Pascual. Heather, how are you today?
I'm doing well, Mike. Thanks so much for having me today.
Yeah, I'm excited to have you because we're going to talk about a contract that I feel like is general enough that you're going to run into this one, right? Like this isn't a type of contract that you're only going to see if you're flying to the moon and you need to bring a dog along with you. This is a common contract. It's called a vendor agreement. Let me share this with the folks at home. This one is as between LA's County Children and Families First and a vendor. It's kind of their form contract. What are you seeing in this document, Heather? What is it? When are we going to run into a vendor agreement?
Yeah, I mean, a vendor agreement in general is one of those where you're buying or selling some sort of product or service from that organization, from that company, and then you want to make sure that the agreement terms are going to be suitable for both sides, and then also covers any provisions in case something happens and you want to make sure that you can rectify those issues as they take place. So that's really what a vendor agreement kind of looks like overall, and then we'll jump into a few provisions here just to understand how to tackle each one of those.
All right, and looking at this one, is there anything in the names of the parties that tells you, I mean, it says LA County Children and Families First Prop 10 Commission. I assume that there's some regulatory whatnot in the background that might make this special in the slightest of ways. But in general, I would say this is probably a pretty applicable to a lot of context agreement. Is that fair?
Absolutely. Yeah. I mean, taking a look first and foremost, just understanding what the parties are going to be in the agreement. That'll give you some understanding as to how to think about some of the terms as well, and how much you might want to push back on some of the language that's included in the agreement. So yeah, it's always good to understand where both parties are coming from and then take things from there.
Yeah, you might understand who's in the power position and who's not. All right. Let's go to the first section, interestingly, is the term of agreement.
Yes.
And I'll read that to you and let me know what you think about this. It says, the term of this agreement shall be from the effective date as set forth in the introductory clause through blank expiration date that they can add later, unless I earlier terminated pursuant to this agreement. So there's some other rules in here, supposedly, about killing this thing. What do you see in that termination clause?
Definitely. I think, here what an initial term really is doing is just setting the starting point for the agreement. So it could be a fixed period, such as 1 year, even like they're doing here, setting it through the expiration date, which the parties will kind of, negotiate what that might look like, and starting with the effective date. Or, even if you want to be a little bit more broad, you could even tie it to a particular project date or milestone. But I think in general, the term should be defined clearly to avoid a lot of the confusion that happens as to when a contract ends, when it begins, and then trying to figure out, some of the renewal terms as well. And then when you think even about renewal terms, a lot of vendor agreements will, just sort of have an auto renewal provision and just have that through mutual consent. There's pros and cons for having an automatic renewal. If you're on the sell side of a contract, then yeah, I mean, absolutely. You want to have this automatic renewal provision in place because it just means that, hey, we're going to have consistent income year over year, essentially until the client cancels the contract. But that if you're going to be on the buy side and you're looking at this and saying, oh, we've got an automatic renewal period here, then that can lead to some unintended consequences for the business itself, and also some, unintended commitments, really. And I think if you want to avoid this from the buy side, you might require maybe some prior written notice from one of the parties or the other, and that will be what really triggers whether or not you're going to have an automatic renewal or renewal of any kind, or if the agreement itself is going to terminate at the end of the term. So those are some things to kind of keep in mind when just looking at the term period in and of itself.
Yeah, and of course, I made a mistake and referred to it as the termination clause. We're actually going to talk about that one later. This is, it sounds like a background term. Let's just, at the very beginning of the contract, say this is when we mean to be hanging out. We'll talk later about how to break that. Number two, the scope of work. This is always highly contested, especially when services are involved. The vendor shall complete the activities and perform the services set forth and described in the scope of work. All right, so they're using this sort of like a master services agreement kind of thing where they're going to set out the background background rules, and then for each particular job, we'll give you this scope over here. It sounds like they might be able to use this again and again. What are you thinking about the scope of work in this section?
Yeah, I mean, absolutely. That's such a good point. I mean, I think, just like a scope of work says in its title, it's meant to provide a nice detailed description of the services, any sort of deliverables that the vendor is expected to provide to the customer itself. And this could include anything from specific tasks, or if there are milestones, deadlines, any particular quality standards as well that the vendor must meet. So, for example, if this were for information technology or IT services, then it should outline, okay, what are going to be the systems that are going to be managed? How will support services be offered? And are there specific, performance metrics that need to be met by the vendor or that they need to achieve throughout that period? So, it's really just outlining a lot of those roles and responsibilities. What I've seen, and, sometimes it'll be fairly general here, and just like how it says in Exhibit A, that will be a little bit more defined. I've seen instances where the attorney sort of just handles the main vendor contract, and then they pass along the statement of work to someone within the business to kind of, go through a little bit more detail and add the specific components. Personally, I like to see these statements of work more detailed than not, but I know a lot of business folks like to kind of keep it pretty flexible and then have that opportunity to change the language in the future if if there's a need to change scope of work or some other deliverable or key metric in there.
Right. And to your point, it says in this section, the vendor will work directly under the commission staff throughout the term who will ensure that the vendor completes the activities, performs the services, and it's adequate, et cetera, which means they've got some statement in here about what okay work is, what quality work is, who gets to decide that. But to your point, this is given a lot of control, unless there's something special in the scope of work document. This is given a lot of control to whoever is the commission staff to determine whether the deliverable was good enough. Does that sound right?
Exactly. Ultimately, the decision is up to them to really make that choice of what to include and how detailed to have the statement of work be outlined. But I mean, exactly to your point, yes.
Yeah, and this really matters because you get down into a section like payment terms, which we're going to talk about, and this is long. I feel like payment terms is one of those things that's actually, is this going to be a net 30? Is this going to be a net 60? But I'm assuming we're probably going to see an echo in here as to what an okay deliverable it is and how that affects the payment terms. What are you seeing in this section?
Absolutely. And so here, even for the payment terms, it's indicating, not later than the last business day of each month, not later than 10, business days after completion of the activities and performance. And so how the payment gets allocated from, the customer to the vendor is going to depend on, what happens with the finance team, what their sort of metrics are with displaying payment. But I think one of the key things to keep in mind is, payment can be laid out whether as a fixed fee, whether it's for time and materials, if it's a per deliverable basis, and also the time periods itself can differ. A lot of companies will say, hey, we'll pay within 90 days, maybe within 30 days, or if they need to have some meat in the middle, it might be 45 or 60-day period for payment. And that's just going to depend on business processes. But, I think it's also important here, just like how the agreement lays out, it's really detailed with the invoicing process and saying how they should be submitted, what the information those invoices should contain, and then the process overall for reviewing and approving those invoices. So even, for example, if you would require the vendor to submit like a monthly invoice, you want to make sure it has those detailed descriptions of the services that have been provided during that period of time you agreed to, and any supporting documentation that also needs to be included in order for the customer to make the payment. That's also something that you would want to lay out. And I think also one other thing, which may have been covered here in this contract, but is having some provision around what happens with late payments, any sort of disputes, how are those sort of penalties or interest that might accrue even throughout, how is that going to be handled? And so outlining that some sort of process or procedure for resolving a payment dispute is I think, pretty key here. And I think, lastly on this point is even with like the currency and taxes, I think a lot of times people might even skip this and just say, yeah, everything's going to be in US dollars. It might just be an overlooked fact, or even whether or not the parties are going to handle, the customer is going to handle like the taxes that are included as well. So if that's going to be included, it should be noted in like a quoted price, or if it's going to be added separately. If the vendor is maybe located in another country, then you want to state, okay, are the payments going to be in the vendor's currency, their local currency, or is it going to be in the currency of maybe the customer if they're based in the US or somewhere else? And then also alongside that, how are some of the exchange rates going to be handled if there are different payment obligation.
Yeah, and to your point about the understanding the parties before you get going with this, I don't know if that's the case with this, whether there are politics involved. This is a county body of some kind, but it sounds like it's related to a proposition. I don't know, but anytime you could see if we're involving politics and policy changes and all of a sudden the budget doesn't pass and whatever, or if you're dealing with parties who you're worried about their liquidity, you're worried about their long-term prospects, just make sure that you're negotiating payment terms in a way that protects you as you're going through them. Speaking of things getting messed up, they do point out that if the contractor submits a fraudulent invoice, it shall constitute a material breach of this contract. There is room in here for breaches that matter in terms of the termination. I'm going to go down to the termination section, and it's pretty long. You're seeing quite a bit of language in here under E. Termination without cause, termination for non-appropriation of funds, termination for cause. What are you seeing in this termination section that's moving you?
Yeah, I mean, I think what's great here is that, it's very clear that it says, hey, if either party wants to terminate the agreement, here's the obligations that each party would have to do. Provide that written notice, and I think the notice, how it's being provided is key. Written is always more preferential than just sort of oral communication. And then it provides a time frame also. So it says at least 10 calendar days before the termination is to be effective. And I place that emphasis on calendar days because sometimes it'll say just 10 days. And then you're left to wonder, is it calendar days or is it business days? And that can also change, how much time you actually have to provide this termination period. And then it also outlines what the vendor would be able to receive in payment for work that it's already completed or otherwise documented, and then how that any sort of refunds would be processed within a period of time after that termination has been taken place. And then also what would happen after the termination. So are the parties going to be liable for any kind of damages? It says here that neither party will be liable. And that sort of lays out sort of a high level with the termination for cause. I think also sometimes a lot of organizations will provide a little bit more period of time, or will want to provide a little bit more time for that notice period. Sometimes they might go as high as even 30 days, just in the event that there's a need to transition some of the business services, maybe find a new vendor, then they want to have a little bit more time to make that transition, especially in larger companies. That might be the case there as well. I think here for the deal size that they're working on, the parties that are involved, I think the 10 calendar days here seems pretty sufficient and pretty reasonable. And if the parties need a little bit more, time to transition services, you can also work out some measures there. But I think, this is good. It's the whole goal of having termination for cause is to provide that flexibility for both of the parties if they need to pull out of the agreement for some reason. But at the same time, it protects both of them in a way that, hey, if we're ending this relationship, the way we handle it is going to be fair. It's not going to be providing a lot of unnecessary conflict, and we can both sort of move on with our business processes after this termination. So I think that this was pretty nicely done.
When it does, to the earlier point, definitely say termination for non-appropriation of funds. If we don't get the budget, we're done with this deal. This is echoing, as I get to a bigger picture question, this is echoing conversations we've had with Siobhan Smith about government contracts. This is a standard form, take it or leave it. Do you want to be on this train or don't you? But you have gone through this list and highlighted, I think, the clauses that are probably the most negotiated, the most debated when you're talking about, a vendor contract. The question is, what's the deliverable? What are the payment terms? How do we end this dang thing? Right. You've highlighted these. When you're dealing with these kinds of contracts, particularly these ones that are formed contracts from presumably a government-related body of some kind, how do you go and negotiate those terms? How do you make that decision to your clients to say, no, you got to push back, or to say to your clients, look, you got to take it or leave it? How do you deal with your clients in that situation?
Yeah, I mean, ultimately, it's going to depend on which party really feels like they have the leverage. I mean, if the client, is a large company and you feel like you would like to maybe do business with this organization for the long term, you can sort of make a few points that sound, great to the other party to say, hey, we would like to push back on maybe this provision, but we're not going to have as much pushback in maybe something else that might be of really big value to the other party. So it's like trying to find that flexibility and see where you can balance each other's interests. At the end of the day, neither party is going to have every single one of their terms be in their favor or wholly on their side for the contract. And so that's the whole point of the agreement itself, is to come to some sort of negotiation, see where your interest can be satisfied at the same time as the other party, and then work through that to be mutual. So I think that, yeah, the way that they, noted it here and also broke it down, for termination without cause, for non-appropriation of funds, here are a bunch of ways that we can terminate if something were to not go into one of our favors.
Yeah, and I think, at minimum, what you need to do is know what's in there, because what you would hate to see is you do something like go hire a bunch of people to increase capacity to meet these kinds of contracts, and they have the ability to kill it if a budget's not passed, which none of you have control over. So just make sure you know what your risks are. Well, Heather, for people who want to understand these kinds of agreements and see what their risks are, what's the best way to reach out to you?
Absolutely. I mean, feel free to reach out to me. You can send me an email at heatherbowen55@gmail.com. You can also send me an email at proactivewisdomllc@gmail.com, or go to my LinkedIn page, and I'll have that information noted there for you. And that's Heather Bowen Pascual. And yeah, I mean, I'm happy to assist you in any way that I possibly can. And I look forward to working with you. Thank you so much for having me again. And if there's any questions that I can answer, be happy to do so.
Absolutely. We'll make sure to have all that information over in the show notes at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show and pick apart contracts like this, just email me. I'm at community@lawinsider.com. We'd love to have you. Heather, thank you again. We'll see you all next time.
Thank you so much for having me.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.